Okay, so we're gonna try again. So we're gonna start with the high level overview of like what the whole trial looks like. This will help you understand like what's gonna happen as a whole so that when you go to look at the case, look at all the documents and evidence you've been given, you can make a plan because you understand how it all fits together. So, okay, so first we're gonna start with the parties. There's oops, the plaintiff or the state. So that's the party that has the burden of proof. And then there's the defendant. There's two sides. We're going to go through the orders of events in a trial, and then we're going to go through the types of evidence that you can use and that you'll see. So, okay. Sorry. I'm terrible at this. Okay. I'm going to go ahead. This is when you do find or replace. Okay. So, in civil trials, we have the plaintiff. And then in criminal trials, you've got the state or the people of the state of Texoma. The state, the plaintiff, they're going to have the burden of proof. So it is their job to prove with evidence all the elements of their claim or their cause of action. So always keep in mind that it is the plaintiff or the state's job to prove their case. The defendant doesn't have this type of burden. And so in a trial, the state or the plaintiff is always going to go first in everything that we do. They're going to present their case or their story about what happened first. So the defendant does not have the burden of proof. They do need to tell their side of the story, and especially like for this competition, you're putting on your case too as a defendant. But and you want to display your trial skills and you want to enter evidence, but the defendant doesn't have to prove a case. A defendant is going to try and poke holes in the story of the plaintiff, and they're going to, and oftentimes, explain their side of what happened. So the defendant is always going to go second when they present their part of the case, their story, that kind of stuff. So here's the order of events. And I think that for me, when I first was in law school and took a class, I didn't understand this piece of it. And when I finally like learned what it actually looked like in practice, it kind of all came together. And so that's why I'm giving you this now, just because if you kind of think about it in terms of order of events, like a production, it helps to understand what you're trying to do later. Okay. Sorry, we've got two states here, but we've got the plaintiff or the state's opening statements. They go first, and then the defendant gives their opening statements. So in the state's opening statements, here's what you're going to do. The state or the plaintiff is going to introduce yourself. Hello, I represent the plaintiff or the state of Texoma. You're going to introduce the witnesses that you have. So you'll probably, for this competition, have 3 different witnesses. You know, here are the people that you're going to hear from today. And then you're going to establish your theme. And so that's kind of your elevator pitch, your 2-sentence, 3-sentence summary of what this case is about and why you should win. So you're also going to go through and explain the elements of the claim or cause of action. And that's going to be in your packet where it says the elements of a cause of action for what I think solicitation of murder is what you guys are working with. We're going to go through an example that talks about criminal trespass. So you want to show them the jury form so the jury knows exactly what they're supposed to be looking for, where the elements of the claim or cause of action are, so that everybody's clear on what you're trying to prove and what needs to be shown. And then in your opening statement, so you say, here's what I have to show, here's what we're going to show, and then you're going to tell what the evidence will show. So this is a part to be careful. Always tell what you know that you can prove. So you're going to hear today from X. This is your witness, you're going to hear from our witness X that they own this land. This is theirs. And they had signs that said no one could be on it, for example. So you're going to go through that briefly. Don't take too long. Just give the highlights that are compelling, and then you repeat your theme, short. That's your opening statement. Now for the defendant, same kind of uh, process here. Hi, my name is Stacy. I am counsel for the defendant, Mrs. X. Introduce your witnesses. Here are the witnesses that we're going to call today. Then you give your theme briefly. This case is about X. And then you talk about, the state is going to have to prove A, B, C, and D. But today we dispute that B and C are met. And so you're going to explain because you want the jury to focus on those things. In your case, for the competition, you may be disputing every single one of the elements. That usually doesn't happen, but you're especially going to want to focus on the ones that you really think that you can poke a hole in as the defendant. So you're going to say, the state has to prove this, but they are not going to be able to prove it, and we're going to tell you why. You're going to hear evidence that will tell you A, B, C. So you just go into that very briefly. You're not presenting your entire case here, and it's not this long soliloquy. You want to give the jury the highlights so they can go, okay, I'm going to pay attention to this element because they say that the state can't prove it. You repeat your theme. That's your opening statement. Next, we have what's called the case in chief. So that is when each party presents their case or like their story of what happens. And you do that through your witnesses and then the evidence that you enter through these witnesses. Each party, for our purposes, is going to have 3 witnesses. So the state goes first, and they're going to have their case in chief. So they get to call each of their 3 witnesses, state witness 1, witness 2, and witness 3. So first, the state gets to put on their witness where they present direct examination. So that's where, if I'm the state, I'm asking my witness questions to get their story out there. The defendant has an opportunity to cross-examine them, ask questions that are difficult to try and poke holes in the story. From there, as necessary, and this isn't something you always do, but then there's redirect. So if I feel like we ended on a really bad note after cross-examination and I really want to emphasize one point, I want to bring something back to explain, that's called redirect. So state direct exam, defendant cross-exam, state can do redirect, and then you can do recross as necessary, but it needs to also be permitted. So that's something that the scope gets smaller and smaller, and we'll continue to discuss this later. So that's what happens with each witness. State witness 1, we go through this, we tell the story, cross-exam, the witness is dismissed. We do that with witness 2, witness 3. So we're repeating all of these things. And as we talked about in the rules, a different attorney for each team is going to take each of these witnesses. So if I'm presenting witness 1, I call them to the stand, I ask the questions to tell their story. Counsel for defendant is going to cross-examine them. I'm then the one that needs to be objecting for cross-examination questions. I also am the one that does the redirect. So if that's my witness, this is all my responsibility. And that also means that another attorney from my team doesn't get to stand up and object or kind of get involved when we're dealing with witness 1. Okay, so then after all the witnesses are presented, the state will rest. Their case in chief has concluded. So they say the state rests, then it's the defendant's turn. So the defendant puts on each of their witnesses. It's the same kind of process where the defendant is going to call, one attorney for each witness. So the defendant will call their witness, tell your side of the story, get out the evidence and, the testimony that you need to establish these elements. The state counsel can cross-examine, and then if you need to do redirect or recross, you can if it's permitted. Then that witness will be dismissed. We go on to witness 2, witness 3, then the defendant rests their case. So now we've, presented both sides of the story through the witnesses. Then we've got closing statements. So we've got the state, because they go first, their closing statement. The defendant gets to give their closing statement. And then we have rebuttal closing statements if you've reserved time. So if you have a certain amount of time to do closing, you need to ask at the beginning to reserve a certain amount of time for rebuttal. So that's something you need to think about ahead of time, and make sure that you ask the court to reserve time. So for the closing argument strategy, so the purpose here is to show evidence that proved or disproved the elements, and then tell the jury what you want them to do. So we talked about this jury form back in the beginning, where we pointed out to the jury, here's what we need to prove, here are the elements. So then you'll have the jury form where they submit, where they're gonna actually say, like, they look at that and they find guilty, not guilty, stuff like that. So you use that form, that here's what you're gonna go use when you go back to deliberate. And we want you to look at these and find that we've proved or disproved. And we ask you to find, for the state, you would say, we want you to find guilty as to this charge. The defendant then would say, we ask you to find not guilty. So then, that's the important part. That's the ultimate goal, right? You want the jury to find in your favor. And then you're going to go back through the elements of the claim, and you're going to walk them through what they saw at trial and the highlights of the testimony and the evidence that will show you each element of the claim. So this is kind of where you say, during cross-examination, this witness admitted that, she had an open door policy for her property. So it's reasonable to think someone could be invited on it if we're talking about trespass. And then you'll revisit your theme. So your kind of catchphrase for your story that you're putting on. So that's kind of what you want to do during closing. Okay. Now we've got types of evidence. So you'll be working with a few different types, but you want to make sure to use all of them to your advantage during a trial. So we've got witness testimony. You're going to have your own witnesses, and that's given in person. That a witness is under oath. They're giving their testimony, and that is something that they promise to tell the truth. And so the jury will take that as truth evidence. Next, we've got like exhibits or physical evidence. And that's something that you need to enter into the record and kind of establish, and we'll go through that later, but that's something that you need to authenticate, establish the foundation, say the magic words, and then that establishes it's something that the jury can rely on as evidence. And then we have demonstrative evidence, and that is not necessarily something that is exactly literally true, but it's something like if we have a map where, if you think about a map, that's not what the world looks like, but it demonstrates where the roads are in relation to lakes and houses and things like that. So that a map is a good example of something that's demonstrative, because you're using it to demonstrate where things were at a certain time or what path you can take. So it's used to kind of show and help the jury understand something that might be like kind of difficult. So pictures can be demonstrative, or like a photograph can either be demonstrative to show what something might have looked like or looked like generally, or a photograph can be used as truth to show what was exactly happening. That's just kind of different ways to use types of evidence, or so think about what you have and how you want to use it. So in your case, you want to use all the types of evidence to get the most points, to show your advocacy skills. And in a real trial, that's what you do too. You want to use every tool that you have to establish the facts of your case that show that you win. So you want to use your witnesses, especially if you can get the witness for the other side to admit something that helps your case. So all the witness testimony you can. Physical exhibits like documents, sometimes in cases where I actually were done some airplane crash cases when I was young attorney, and there was actually a trial where they wanted the jury members to see like a piece of a door from this airplane that fell off. And frankly, that's kind of um, uh, there's good reasons where you could keep that out, but it also is something that like that is a physical piece of evidence that was part of the crash so that the jury could understand there's an issue about whether the door did what it was supposed to. So you also have demonstrative exhibits. So maps, pictures, even just like a drawing sometime could be demonstrative because it's you're not saying it's true, but it's helping the jury understand the other information that they're getting in the case. Another type of important evidence is impeachment evidence. And this is actually like the really fun type of evidence because impeachment is like discrediting somebody. And so if a witness for the other side testifies to something, to a specific fact, but there's evidence in the record, and you're going to see this as you go through your case where you say, they said the pen was red, but if you look on the actual document that we have, the ink is blue. So there's evidence that shows that like this witness maybe can't be trusted. So you're not necessarily trying to prove you're not really trying to prove necessarily that it was blue. You can be trying to prove that, but you're trying to discredit the witness. That's what impeachment evidence does. So, so you want to be prepared to impeach a witness on the other side for holes in their story or to discredit them to show maybe that they're biased and they're just not telling the truth all the time. Because that's something that's really important to the jury, and the jury gets to decide is how much they believe someone's story. The other piece I put in there is the bonus, and we talked about that earlier, but if you can get the other side's witnesses to admit something in your favor or give testimony that helps, that's going to be really persuasive. And so that's something that judges like to see for the competition, but also that's really persuasive in real life. When someone called another witness and then they end up, admitting an element of the claim that you needed, that's great. Okay. Objections. So I'm going to go into this just briefly, and we're going to go into this in more detail later. But we
I have a
talked about,
question.
oh, sorry.
I had a question. My name is I'm Dr. Cross. I just wanted to know with the evidence, because it's our first time joining into the
Yeah.
Texas High School mock trial. So with the evidence, do we make our own evidence? I mean, create our own evidence out of the documents that we have, or do we do that?
Yes. So
We do.
that's a great question. So your trial packet will have so you'll have three witnesses and you'll have witness statements. So that is basically like the testimony that your witnesses need to stick to. That is what they have to say. So if the witness statement says, I saw a red pen, that is what they're going to have to say. Now, you don't have to put all of that information in your direct examination. You don't have to bring it all out, but that's kind of directing you to the testimony that witness will give. You'll also have other documents like in your trial packet. And so those are like the physical pieces of evidence documents that you're going to use. So you are limited to what is in your packet. So you'll also have sometimes there's pictures, something like that. Those are the demonstrative pieces of evidence as well that you could use for one or the other thing.
Yeah, I'll just chime in here just for clarity. At the
Yeah.
end of there's the document that says case materials, which is like the actual case packet. At the very end are exhibits, and they are labeled as exhibits, and they are pre-numbered. So those are the exhibits that you are allowed to use. You are not allowed to use other exhibits. And we'll talk a little bit more about exhibits
Yeah.
specifically as we go along. But I just wanted to provide that clarity that
Yes.
no, you're not making up anything, you're not creating anything. The case has the exhibits for you to use or
Yeah.
not to use if you don't want to.
Exactly. Yeah. You probably won't use all of them, but you want to use as much as you can to help your case. Okay. So thank you. That was a good question. And thank you for kind of like chiming in because sometimes I am missing, the flags or anything. So
No, I thought your answer was great. I just wanted to be very precise
yeah,
about exhibits specifically.
no,
Um, and just to clarify, I did get a question about closing statements. I want to answer that before I forget that it exists. Um, only the state gets a rebuttal. The defense does not get a rebuttal closing argument.
right. And that kind of keeps in line with like the state or the plaintiff, they have to prove their case. So at the end of the day, like they're the ones that need to be able to establish whatever it is. So the defendant doesn't necessarily like you're not really entitled to a rebuttal because it's not your job to prove the case.
And just in
So,
case you do internet research, and usually with the cases that Stacy and I do, we actually can, as plaintiffs, rebut. We have basically a chance to put on more evidence after the defense. We do not do that in mock trial. You do your entire case in chief, the defense does its entire case in chief, and then we move on to closing arguments. There's no rebuttal evidence opening options.
Right. No surprise witnesses called.
No surprise witnesses.
Yeah.
Somebody started to ask a question. I'm not sure who it was.
yes, this is Dr. McCullum from C. King High School.
Yeah.
I wanted to ask, as far as closing go, do that extra time that the students have to reserve, is that used in, do they have to do that in housekeeping? When do they have to put that out before they can
So
reserve that time?
yeah, no, that's a great
Good
question.
question.
Technically within our rules, you don't actually have to reserve the time. You just get up to whatever's left, up to 1 minute. But generally at the beginning of their closing statement, the prosecution would say, at this time, I'd like to reserve 1 minute for my rebuttal. Is kind of housekeeping wise when you would do it. You wouldn't do it at the very beginning of the case. You would do it when you're doing your closing statement.
So
And
after
then
both
it's
parties have rested. Yep.
exactly. And so then it's up to the timekeeper and the attorney doing the closing to keep an eye on the time to
Mhm.
make sure you do it. So like, let's say you go over your closing is 5 minutes, you can reserve up to 1 minute. So let's say you end up going 4 minutes and 15 seconds for your initial closing. That means you only get 45 seconds for your rebuttal. You don't get a
Awesome.
full minute.
Awesome.
Okay. But if you
And one more
have,
question.
let's say you had 1 minute, 15 seconds left, you still only get 1 minute.
Yeah. And that's
Right.
the mock trial
Okay.
rules.
So that's just the rules we have in place. What's your next question?
My next question is on the demonstrative exhibits, the exhibits in the case material that's evidence at the end of that's in the case material.
Mhm.
Is all that evidence pre-marked? Do they have to establish that the evidence is pre-marked, or do they have to
No, so
generally have that evidence marked while trial is going on?
yeah, no, the assumption is that it's pre-marked. What you would do is just print the exhibits. You would just print the papers at the end of the
Yep.
case.
Yep. So that is what
Um,
you bring.
Yeah, so you would just bring those. And so like I pulled it, I haven't like looked at the actual case, but there are 16
Yeah.
exhibits. You would just print each of them separately. So you don't want to have like 1 and 2 put together. You want 1 and 2 separated, for example. And they're already marked, so nobody has to mark them. So as long as you just print them as is from the packet, they don't have to be in color. You know, everybody knows what the exhibits look like. So and again, we can get into that the nitty-gritty of actually introducing exhibits, but yeah, you don't have to, nobody has to mark them in trial. Everything will be pre-marked for the purposes of the trial.
Yep. And we will
Awesome.
go through a little bit later, like how you enter them and stuff, like the things that you need to say. But for purposes of like identifying them is like, this is exhibit 2 or whatever, like that is done for you and everyone knows what that is.
Mhm.
Awesome. Thank you so much.
You're
Yeah, no
welcome.
problem. Okay, so now we're going to go through objections at a high level, just because this is something that like people focus on a lot, and sometimes people focus on this more than they focus on kind of their case. So I want to touch on it now to talk about like the purpose and what happens, and then when later we're going to go into like some like substantive objections and the actual like what we're actually you can say and how you respond. This is just kind of like when it happens and how it happens. So let's say I'm a state and I am putting on my witness through direct examination. And I ask him a question, or there's a piece of evidence that I want to use. So the other side, whatever attorney is assigned to that same witness, they are going to object to something that I have done wrong. The question isn't right, whatever. So they would stand up and raise the objection during my direct examination. So they're saying, objection, Your Honor. So the mock trial rules in the packet that you have will have a list and identify these different types of objections. But when it happens is like when someone stands up is like during this direct examination for this witness, whenever the record comes up. So when you want to object, what you do if you're the other side, You stand up, you say objection. So you state that to the judge. You don't say it to the other side, you say it to the court, and then you explain the reason for your objection. So that's some of the substantive stuff that we'll talk about. But you'd stand up and say, objection, Your Honor. Here's an example. This is prejudicial and it's prohibited under Rule 403 because this is more prejudicial than probative. Remember how I talked about how there was an airplane crash case where a door from a plane that had crashed was brought in? That was a time when they objected and said, this is absolutely prejudicial. You're going to see this burned door, and they're going to conclude that we're responsible regardless of whether they are or not. So that was exactly the objection that was received. So the objecting attorney says their objection to the court. The opposing counsel, you wait. The judge will look to you to respond, and then you're going to respond to what they said. So I'm going through Rule 403. Don't worry about the substance of this, but I would say, hey, Your Honor, this evidence is highly relevant and it's probative of the element of blah, blah, blah. And the prejudice is outweighed by the probative value. So don't worry about what I just said, but I'm responding to this specific objection there. So someone raises the objection, look at the court, you respond, then the court is going to rule. So sometimes the judge will ask for another response, but the most important part is the objection, the response. So the court will either say sustained, and that means if you stood up and you objected, you win, and the evidence is not coming in. Or the judge will say overruled, and that means the objecting party, you didn't win, and they're going to proceed and let the evidence in, or proceed with their line of questioning, whatever has it. So sustained, overruled. Okay. So here's another just example. Objection. This testimony is prohibited hearsay because it's an out-of-court statement being used to prove the truth of the matter asserted. The attorney says, response, this is not hearsay because we're not trying to prove the truth of the matter being asserted. We're using this to show motive. Okay, so important piece about evidence and objections. So be prepared. So when you're going through the case, you're going to look at different things and you're going to review the evidence and kind of anticipate like an objection that the other side might want to raise and how you'll respond. So this is something that as you get, as you're going through and making your case, you're going to start thinking about places where you would object to certain testimony or evidence. And then you're going to think about places where the other side might object as well. And when you're preparing for the competition, you have to prepare to do both sides of the case. You have to be ready to be the plaintiff or state. You need to also be ready to be the defendant. And that will switch from time to time. And so the best way to prepare for a trial is to know exactly what the other side is going to do. So this is something that will come up as you're preparing for your case. You'll realize where there will be objections because you're also preparing that side as well. So if an objection is raised, stay calm. Just, don't respond. Wait for the court to indicate you should respond. Sometimes the judge will just look at you. Sometimes the judge will say response. Now, this is an important one, and this is one that I, in law school, did a few times incorrectly. So if an attorney says objection, Your Honor, and says whatever they want to say, you don't look at them and respond to them. You are only talking to the court, the judge. The judge is like the parent in the room. They decide. You are never conversing with the other side without the court there. So only address the judge in the response. Other tip is just listen exactly to what the side says about their objection. So respond to what they said and the grounds that they raised. So, and the other thing is when you're not really sure what they said or like what the legal rule or grounds are, use the same language that they used. So for example, when I gave that example before about prejudicial, They said, objection, Your Honor, this is prejudicial. Well, a rule of thumb is to say, Your Honor, this is not prejudicial. So I don't even have to know what that means to at least respond in a way that is like somewhat addressing the matter. So, that's a good rule of thumb to think about, mirror their language. But as you prepare more and more, you'll get more comfortable with like the actual things that you need to say. Okay. If an objection is sustained, which means they won, your question was not correct. So sometimes try rephrasing your question or, asking different questions to establish the foundation or whatever you were missing. So sometimes they'd say, they haven't established she has any knowledge. They haven't established she was at this place at this time. And so you go, okay, let me back up. Were you there on this date? Yes, I was. Do you wear glasses? No, I don't. Can you see clearly? I can. Okay, were you there at this time? Yes. So that's kind of where you go, okay, they objected. Sometimes you can really easily correct it by just listening to what they said, backing up and making sure you lay out things piece by piece. Now, the important part is if the judge rules against you, shrug it off, move on. Don't, that's kind of where a lot of people feel like, oh no, I'm losing. But really, you know what? You just have to adapt and move on. And the important thing is that the jury is going to see like, oh no, a lot of times they look to you to be like, was that bad? Are they losing the case? And if you are freaking out or don't know what to do next, the jury kind of says, oh, it looks like they're not as strong as I thought they were. But really, if you just kind of move on and go, okay, we're going to move on. Next question. I'll start somewhere else. That's kind of where like you can really gain points and credibility if you keep your cool and just move on and go to what you know. And that is like very true in real life. Okay, so that is that part. Going to stop sharing for one moment. And then we will move into like kind of dissecting the case. Do you guys have any questions about this stuff before we move on?
Okay, and like Stacey said, we're gonna get a little bit more into the
Yeah.
weeds as we go along. She was kind of trying to do like a high level
Yes.
explanation because we know a lot of you have never done this before. So if we started talking very specifically about leading questions, for example, you'd be like, what are we talking about? I don't know what an
Yeah,
objection
yeah.
is. So we'll get a little bit more into the weeds as we go along. Dr. Cross, you have your hand raised.
I do. This is very new for us, but
Yeah.
I wanted to ask, is it possible we would get access or a copy of the PowerPoint presentation so we can explain to our students the exact same way? I was just wondering if that's possible.
So yes, what we typically do is I'll send a PDF of the PowerPoint slides to everybody,
Mhm.
or I send it to Melissa and then she sends it out. But also these are gonna be on YouTube. So what I'm saying right now is being recorded and it's gonna get uploaded to YouTube in the next week when Melissa has time. So you can literally just sit your students down in front of it and they can watch the exact same thing. Um, that's an option. But yes, it's all gonna be made available to you as well.
Okay, thank you so much.
You're welcome.
So Jessica, I was actually, so in this like dissecting the case and making the plan before I had like woven in the Little Mermaid thing, which is not a part of it. So I can either just skip over those parts, or if you think it makes sense to like bring up that case to like give them the background, the Goldilocks one, we can do.
Yeah, let's talk about the Goldilocks one
Okay.
first.
So
And
let me
then
unshare and then we can go in through this part. If that works.
are you wanting me to do mine first
Or
or
just like go into the back, like the facts of it.
oh, okay.
So that,
Yeah,
yeah.
I don't actually have a fact thing, but hopefully everybody
Okay.
knows of the story of Goldilocks
Yes.
and the Three Bears.
Perfect.
Um
Perfect. That's good.
so we'll just wing this part. We don't really have a
Good.
PowerPoint for you guys. Some
Okay.
miscommunication
Yes.
between us, we'll just say that. So I'll just give you brief fact thing, and then we can skip the Little Mermaid specific slides, but maybe go through the ones where you're
Yeah.
talking
Okay.
about the steps. So hopefully everybody remembers Goldilocks and the Three Bears. Goldilocks goes into the house of the Three Bears. The Three Bears are not there. She tries out the chairs. Papa Bear's is too big, Baby Bear's is too small, Mama Bear's is just right. She tries out their porridge. Papa Bear is too hot, Baby Bear is too cold, Mama Bear's is just right. And then she takes herself over to the beds. Papa Bear's is too hard for her, too uncomfortable. Baby Bear's is too soft. Mama Bear's is just right. And she takes herself a little nap. So this year in the state of Fairy Tale Land is the state versus Goldilocks for the crime of trespassing, because she is, of course, a trespasser. Now, Stacy's going to walk us through how you would analyze that, how you'd break it down. And then the next part, we're going to talk really more specifically about questioning of witnesses, presenting the evidence, that sort of thing.
Okay. So the first thing, so we went through like kind of the overview of like what a trial looks like and what happens. And next you get this big packet of information, and it's got these, the rules, all this evidence we talked about, witness statements, and like it's just a lot of stuff. So it might seem overwhelming at first. And so the thing that you need to, so this is kind of like, you're like, okay, what do I do next? So what you need to do is like, we're going to talk now about how you kind of review your materials and then make a plan for how to present your case, because that's kind of like where you need to start. So if there are some examples that don't apply, we will ignore those, but we can also on the fly come up with some Goldilocks ones since we all know the story. So sample case, dissecting the case, how to read and analyze, and then make a plan, how to put together your case. Okay, so the sample case is Goldilocks. We just went through that. Now, how to review and analyze your case. So we talked about in your case materials, they are going to be the elements of the crime or the cause of action, because that is what they have to prove. So if we're talking about criminal trespass, the elements of that cause of action, at least in the state of Michigan, is that a person is knew or had reason to believe that they were on the property owned by another without permission, or unlawfully stayed after a lawful request to leave the property. I've been doing one of these cases, so that's fun.
And that's more or less the definition in Texas as well.
Right.
It's like basically, essentially, you either have notice that you're not supposed to be there and you go anyway, or you go, you're told to leave, and you stay. It's
Got
kind
it.
of one or the
Yes.
other.
And it is not your property.
Yes.
So what we do is we read those elements of the cause of action. You're going to see that it's like a bulleted list, and it'll say the law of the state of Texoma says, and then it gives those elements. And so that is your map for this entire case. If you have one thing that you like put on your bulletin board, it is those elements, because that is guiding you on what you have to prove or you have to disprove. So then you'll have witness statements, and that is like a typed up sheet, and that is the testimony that we talked about that the witnesses are going to be tied to. They do not get to change what is said in that witness statement. They might have multiple witness statements. So they might have, submitted one witness statement, and then they submitted a short paragraph later that says, I forgot to mention that, or I need to correct this. But that is what you can ask the witnesses about. That's what they can say. They don't really they don't get to like add details that like might change the case. So you read the witness statements for both parties, not just your witnesses. So start with yours or start with one side's, but read all of the witness statements for the states and then read all the witness statements for the defendants, so that you know all the kind of like stories and narratives that are in play. Next, you're going to read, so you read all of them. There's a lot of reading, I know, but then you read them that are relevant to your case, because these are your witnesses and this is your evidence. So these are the witnesses that are helpful to your side, that you can control the questions for. So you're going to say, for example, if I was the state, you would go and say, okay, I'm going to reread Mama Bear, Papa Bear, and Baby Bear, or the Bear Family Trust and a bird that was on the property, whatever witnesses it is, then review yours because that's what you're going to start to work from. Then go back to the causes of action, so all those elements, and match the evidence to the elements to build your case. So when we say, for example, we have to prove Goldilocks was on the property of another. So if I am the state, I need to prove that this property is owned by someone else. So maybe that's Mama Bear, who I'm going to use her testimony for that element. And I'm going to make sure that say, okay, when I question Mama Bear, I have to say, now, do you own this property? And Mama Bear says, yes, we have owned this for 20 years. Okay, so that's how you kind of like go through and match that up to each element. Elements of the cause of action, we just went through that. So the next part is the legal standard. So this is something that's important, and it's important to talk about, but in a criminal case, the state has to prove each element beyond a reasonable doubt. This is higher than in a civil case, but kind of if reasonable doubt exists, or if, for example, you're Goldilocks, the defendant, and there's some doubt as to whether she knew she was on someone else's property, or she thought she was on hers, or she thought she was in a park. If there's some reasonable doubt there, then the state hasn't met their burden, and that's something the defendant is going to point out. And that will, if there is reasonable doubt, then the jury must find that they are not guilty. So there are disputed elements that have to be proven, and so you want to focus on the ones that are easiest to dispute. So oftentimes in a case, so if we're talking about criminal trespass, maybe you don't dispute that the land is actually owned by Mama Bear, because you know what, it is. But we do dispute whether or not Goldilocks knew about it. So you're going to really, because you've read all the evidence, right? You've looked through everything. And so you're kind of saying, looks like there are arguments here on both sides, or we have the best argument to say she had no idea she was trespassing. There's an intent element here. And so she's going to testify. We're going to have lots of evidence showing that it might have been reasonable for her to think she was just in a park. Okay, so when you make your plan, you have to prove each disputed element with supporting evidence. Okay. All right, so this is giving a different example, but you review the witness statements and exhibits, and then here's how I do it, is I always say, after I read the materials for each element, I say, how do I know that? So when we're talking about how do I know that Goldilocks knew she was on someone else's property? So maybe an example here is there was a fence, or there was a sign that said keep out. So that's an example that gives you the evidence that's important to show that claim. So I always ask, when you look at the evidence, say, how do I know that blank for each element? And that is kind of what's telling me, here's the evidence that I need, or here's the evidence that disputes this too. So if I'm the defendant, if I'm Goldilocks, I'm going to say, how do we know that Goldilocks thought she was welcome on the property? Well, because Goldilocks will testify that the Bears had this standard policy of everyone can come on and eat our porridge. We have potluck suppers every Tuesday. And this is a Tuesday. So, she thought she was welcome. So that's an example of evidence. That's how I know that Goldilocks reasonably thought she was allowed to be there. All right, guys. Okay. So we talked about that. So each side does that, the state and the defendant. How do we know? So here's, I got to update this one. So evidence of knowledge. How do we know if defendant or Goldilocks knew she was on property owned by another? So for the state, we'll say, Mama Bear, the property owner, is she going to testify? She put up signs. Is she going to testify about a fence? Are we going to have a picture of a sign that shows us like what was at the entrance to the house? Was there a lock on the door? So that's kind of an example of like, okay, that would be how we would know that Goldilocks should have known she was somewhere that she wasn't supposed to be. How do we know if Goldilocks reasonably thought she could be there? So was the sign visible? Was the door open? Was there this open door policy, this potluck? And then we'll talk about exhibits. So there might be a picture of the sign. There might be kind of a map of the property with the park next to it. So those are kind of like evidence that would go toward one side or another on this element of knowledge or belief. Nope. Okay. So that was, I kind of went through both there, but the defendant is going to do the same thing. So the defendant has a little bit broader of an ability to find evidence that disproves or negates each element, because sometimes the only evidence that the prosecution will have is the testimony of a witness. But if you can kind of show that that witness doesn't always tell the truth, so that's kind of where impeachment can come in. So even if it's not directly on that point, but if you can say, listen, we impeached this witness. He was lying about a red pen versus blue pen. He was lying about, inviting people to his potluck when we all know that, there are people there every single Tuesday. So if you can kind of call into question, that's another way to like tangentially discredit evidence that goes to a particular element. So this is, okay, so creating a theme for your case. So we talked about how like your opening statement, your closing statement. So we've now gone through the elements, we've gone through all the elements and we figured out which evidence goes. Now we have to create a theme. So this is your elevator pitch, but this is like this is your story, your one-liner. So maybe this is a story about, for the Goldilocks, this is a story about, I don't even know. This is a story about being invited onto property. This is a story about like sharing with your neighbors and inviting them on their property, and they think they can be there, and now they're mad that she came and ate the porridge like they invited everyone else to do all the time. So, you can kind of, that's what you say, and that kind of shows what we're going to talk about this whole time is how Goldilocks was fair and thinking she could be there every single Tuesday. This was a Tuesday. Everyone could come eat porridge. And now that it happened to be Goldilocks, she's getting in trouble for it. When she reasonably believed she could be there and she reasonably believed she could eat the porridge. So that's kind of how we are going to frame everything. So the case theme is going to be kind of a memorable phrase or just a general, like a sentence or two that's going to help the jury remember how you're framing the argument. So like in the O.J. Simpson trial, they said, you guys may be like too young for that. The famous line was, if the glove doesn't fit, you must acquit. And the glove did not fit, and the jury acquitted. So I don't even know what this example is for.
I think it was from the case we had a couple of years ago where there was like a fire or something. I don't know.
Yes. Yes. Birthday party magicians aren't life-threatening. Yes, that is. So anyway, these are just kind of things that like your one sentence, your two sentence statement that like you can remember. Sounds
I would say like if you're the defense for Goldilocks, it's you can't trespass if you're invited in.
Yep. Mm-hmm.
Like she's invited to be there. I don't know what the states would be. Like, don't trust blonde girls. I have no idea. Like,
yeah. Yep.
Don't trust human girls or something.
Yes.
Because we're talking about fairy tale land. Um, but something that just kind of summarizes what you want the jury to be thinking about as you're going through.
Yep. This is a story about girls who cross boundaries. Um,
Ooh.
Something like that. So this case theme, like figure that out once you've figured out how your evidence comes in, how you figured out what your story is about. And this is going to come in, you're going to build this into your opening statement, like we talked about. And you're going to try and revisit this during your direct and cross exam. So especially bonus points, if you can make the other side's witness like say this phrase or agree with your theme. So, if you're saying, if you're cross-examining Mama Bear or Papa Bear and you say, have you had, a potluck on Tuesdays with porridge? Yes, I have. And, you invited people to eat porridge, right? And those people weren't trespassing, right? So, you're not trespassing if you invite someone, right? So that's something where you can kind of go through and you're revisiting this because that's what you're trying to show. This is the story you're trying to show. So you repeat your theme, not too much, but you're trying to revisit this all the time because it really is your story. It's what you're going to show. So the way to actually kind of like write it down, and I think this is just the best way to start, is you create your proof outline and then your scripts essentially for your witnesses. So we talked before about how you have your each element. So this is your outline. Your element, each section of the outline is one element. And so you go and you list exactly the proof that's going towards each of those. And then let's see. So make an outline of the elements of the cause of action and write out the proof, write the witness, and like what they would say or like what their witness statement says. So you'll see that like in their witness statement, it'll say like, I invited community members to have a potluck. It was usually on Tuesday. We served porridge. It's like that's what you would like put under there because that's what you want them to say. If there's exhibits, so look through the documents that establish this. If there's like a flyer that says like bear porridge party, like come one, come all, that would be an exhibit that is going to help us show it was reasonable to believe she could be there. And then you also, so we talked about direct examination statements, exhibits. Then we also talk about like cross-examination points. So how do I prove this through questions that I ask a witness for the other side? Sometimes you have one and not the other. So sometimes you can only do it through cross-examination. Sometimes that's the only way, and especially for the defendant, that's often how it's going to be, is that you don't have someone standing up to say, you might have, none of your witnesses might have been at those porridge parties. So you have to ask Mama and Papa and Baby Bear about that. So you always, though, want to be familiar with other side's proof and then ways that they might try and discredit your witnesses or objections, things like that. So this is called your proof outline. This is standard. Like I do this for every case because it's your backbone of your case. It's what you have to prove. It's what we're working with here. Then, so then you create your scripts. So for your witnesses, you're going to make your scripts. What story do we want to tell? And make sure that all of these elements that the witnesses can talk about, you want to make sure that that is included within their story, right? The next part of this and the next layer is the exhibits that we want to enter and use with those witnesses. So the witness is going to have knowledge about an exhibit or be able to have some type of understanding so that they can talk about it. You can't just like ask a witness about something they've never heard of or, thought about. So, for example, like if you ask Goldilocks about this flyer that's talking about porridge parties at the Bears house, that's something you'd want to ask her about, or maybe other witnesses about, to say, okay, like, have you seen this before? And she's like, yeah, this is what I was talking about. And so we'll go through the way that you do that. There's a process and specific things you say, but that's an example of the document, the piece of evidence that I'm going to use with Goldilocks in her script. And then there's also like these weak points. So let's say I'm talking about Goldilocks and there is a fence. Okay. And the gate was closed. And so like, we have got to address that, right? So this is a part of preparing and knowing what's out there because you've read everything. So you say, all right, well, they're going to testify about this fence and we've got to talk about it with Goldilocks. So maybe talk about that later, but you want to be prepared in this Q&A to sometimes address stuff that isn't so good. Sometimes there's not really a good way to address it, but generally you should. If it's something that's difficult, could go either way. So that's something to consider doing. So we've written our witness Q&As, and that like takes some revising, but you're going to be referring to your outline. You're going to say, okay, I need to prove this. This witness does this. This document does this. And so it's kind of your mapping from one to the other. And because each attorney is going to be assigned a witness, like on your team, so it's good because one person will be thinking about what Goldilocks knows and what she can say, while another person will be thinking about what, I don't know, a bird in the woods can say and saw that day or something. So just remember, like, one attorney will be responsible for one witness. So that's a good way to break it up sometimes, but you all want to be familiar as you go forward. So we've got the witness examination scripts for your witnesses done. Then we're going to write the opening statement. So you remember how we talked about the opening statement, how we said you're going to hear from Goldilocks and the bird in the woods, and you're going to hear about how Goldilocks had heard about these porridge parties and they were on Tuesdays and today was a Tuesday. So she thought she could come. And you'll hear from the bird that it was a Tuesday and the bird usually saw lots of people walking to the Bears' houses that day. And Goldilocks did the same thing on the Tuesday. So that's kind of like the little highlight pieces that you're going to be able to get in with your witnesses that you're going to talk through in the opening statement. So we made our direct examination scripts. We've written that part of our opening statement. Then we're going to do our cross-exam scripts. And this is like the fun part, but it does take a lot of thought. So we'll get into some more of that, but the cross-examination is really poking holes in their story, trying to get that, trying to emphasize what a witness doesn't know, using some of the evidence to if you can use documents to impeach them. So if a witness, we talked about how sometimes witnesses will have a long witness statement and then a supplementary one. And so that's always a time where you can cross-examine them and you'd say, okay, well, you said in your testimony that ABC, but didn't you provide a supplementary witness statement that said the exact opposite? And like, weren't you under oath both times? Like, how can we trust you? So that's an example of like something that you would use to impeach a witness that would go in your cross-examination script. So when you're writing your closing statement, you want to revisit like highlights of the evidence that you will use to prove or disprove the case. But you also, and here's where like you get bonus points, right? Is when you can tweak your closing statement when you're kind of saying, what did we hear today? We heard Mama Bear say. And you want to be able to adjust and make sure that like it actually reflects what Mama Bear said during the trial today. So a lot of times you can kind of like, what's going to come in and stuff, but maybe it doesn't, or maybe she says something a little different. So you want to be able to like adjust a little bit to make sure that your closing statement reflects what actually was said, or the cross-examination points that were actually made during the trial. So if there was an objection and something didn't get to be asked about, there was this piece of evidence didn't come in, you do not want that in your closing statement. Okay, so that's kind of like the high level. We'll get into a lot of the details, like the substance of objections and stuff, but do you guys have any like high level questions on this? Nope. Great.
Okay, is it my turn now?
Yes,
Okay. Just wanted to make sure I wasn't talking over you.
you're good.
Okay, so now we're gonna get into kind of a little bit more of the weeds, like Stacy and I were talking about getting a little bit more specific. I will say the one thing I don't have in here is opening and closing statements. Stacy kind of gave high level stuff, so at the end we'll kind of give some tips and tricks about that. But I don't have slides for those, just so that we're all on the same page. So no one's going like, oh, your slide's missing, or whatever. It doesn't exist. I'm sorry, I forgot. So we're gonna start with witness examination, which is also known as direct and cross. Okay. So if ever anyone says it's time for exam, like that's what we talk about.
Yeah.
It's exams. I don't know why we're lawyers. We use weird terms for things that we understand and other people don't. So part of what Stacy and I are trying to do is like break down that language barrier and make sure if these terms are used, you know what it's talking about. I'm
Yeah.
pretty sure the rules reference witness examination, and so that's why I'm trying to make sure y'all know exactly what that is. That's direct examination, that's cross examination, that's questioning of your witnesses. Okay. So generally speaking, a trial is a story, right? We're telling a story to the jury. We have two competing stories. So we're trying to convince them one story is better than the other. In a criminal case, the state has to prove their case beyond a reasonable doubt. So it's slightly different. Like in a civil case, I want them just to believe my story a little bit more than they believe Stacy's, right? In a civil case. In a criminal case, if I'm the state, they have to believe me beyond a reasonable doubt. So Stacy doesn't even really have to convince them she's completely correct. She just has to convince them she's a little correct. She's correct enough that my story isn't beyond a reasonable
I
doubt.
could be correct.
There's a reasonable chance
Yeah.
she could be
Mhm.
correct. So one of the examples, and I don't have a slide for this either, but I'm gonna kind of break down beyond a reasonable doubt for you guys because we love you, because you're beginners.
Mhm.
Um, the way I always explained it beyond a reasonable doubt when I was a prosecutor was you wake up in the morning, you go outside, your grass is all wet. The sidewalk is wet. The street is wet. The car is wet, right? Everything is wet. It is incredibly reasonable to believe that it rained. If all of those things are wet, that's reasonable. Okay. If Stacy comes in and is like, oh yeah, but it might have been a water tanker flying through the air, like they do over farm fields and stuff or fires, right? Where they're putting fires out with the airplane tankers, right? You know what I'm talking about. Does that make sense? Helicopters, whatever. And she's like, no, it was really this. Like, is it reasonable that that happened in this situation? Probably not. So you don't, just because it is an option, it doesn't make it reasonable. Okay. So it has to be something that reasonably could have happened. If it's only my lawn, my yard, my sidewalk, my car, it might be reasonable to say, hey, your sprinkler broke in the middle of the night and went off, right? That might be a reasonable alternative to the rain theory. So when we talk about reasonable doubt, that's where we're at. And so in a criminal case, I'm trying to convince you beyond a reasonable doubt. Stacy's trying to poke holes in that as the defense. So a witness on direct, you want them to tell the story of your case. You want them to build the story. You want to help the jury understand why your story is the story, why it's correct. If you're taking a witness on cross, you want to make sure they're not poking holes in your story, first of all. You want to poke holes in their story, or you want to get them to agree that no, actually, you're right. It did rain last night. I saw the weather report, right?
Yeah.
So in a criminal trial, we're always going to try to connect our story to the elements of the crime. We don't want to just talk about things for the sake of talking about things. We're not going to be questioning Mama Bear about the fox who lives 3 doors down who likes to steal porridge. Like he might steal porridge, but it's not really relevant to the question of whether or not Goldilocks was in the bear's house that day. Right? And remember, no witness can confess to the crime. So do not put in
Yes.
your scripts, did you commit the murder, yes or no? Okay. I mean, you can, but the witness answer should always be no. Okay. And Stacy went through this just a little bit, but I put it in there just
Yep.
going back to the rules. Stages of examination, we're going to start with a direct, then there's a cross, there's a redirect, there's a recross, and then we're excusing the witness. We don't go past that initial recross.
So let's talk about scope for this part.
Yeah, so I will also say before we get into scope, you are not required to redirect or recross.
No.
Okay.
Sometimes like don't do it.
Yeah. In our rules, it's not required. It is an option. So
Mhm.
if they go through their cross exam and you're like, I don't even need to redirect, you don't have to. Now I'm going to say if something real bad came out on cross and you don't redirect, I as a judge am going to probably give you that like -1 or -2 depending on how egregious it was. Sometimes the redirect is like one question, right? And then that's when scope matters because redirects and recross are limited to the scope of what has already been discussed. Okay, so Stacey, you want to explain scope a little bit more?
Yeah, so for example, in redirect,
Oops, sorry.
no worries. So let's say we're talking about like whether or not Goldilocks, it was reasonable for her to know that she was invited or reasonable to believe she was invited, right? So we're talking about there's a history of these porch parties and there was flyers and they happen on Tuesdays. And on cross-examination, you talk about how well they didn't happen every Tuesday or something like that. So like we're keeping in the scope. The cross-examination then talked about like, was it every Tuesday? Was it always open to everyone? So if I'm gonna go, and it sounded really bad, right? So it didn't leave on a good note. It was bad. So I gotta stand up and do some type of redirect, right? Because they were only talking about these porch parties and when they occurred and who was invited, I don't get to go back and say like, uh, but remember there's this fox and the fox ate porridge. That has nothing to do with what we talked about regarding these porridge parties. So you have to keep it in the scope of the content of what was talked about in the cross or the redirect. So the scope is going to just keep getting narrower and
Yeah.
narrower. You don't get to stand
Yeah.
up and bring up something else.
So let me give you another example. Let's say Goldilocks hires an expert witness or hires a witness and they're being paid to testify for Goldilocks.
Mhm.
They're being paid the
Right.
big bucks because they are experts on like porridge parties or whatever. And the entire cross-examination is about how much they've gotten paid. And so now Goldilocks is like, ooh, that felt really bad. On redirects, she can ask questions to kind of soften that, right? Like, okay, yes, you're getting paid, but you tell the truth, right? Like you don't just make up, you're getting paid to tell the truth. You're not getting paid to make up a story. Da, da, da. She can't then go, but like also let's talk about your expertise in fox hunting.
Right.
Our analogy is getting really off the rails very quickly because
Right.
but you can't really go outside of like if that cross-examination was only about the compensation, your redirect has to be really limited to that compensation question. And then the same for recross. You can only recross on what they talked about in their redirect. So sometimes recross is really pointless because like there's literally not a question I can ask at this point other than just beating a dead horse.
Right.
And I would say no when you're beating a dead horse. If the same question has been asked on direct, cross, and redirect, you maybe don't need to ask it again on recross.
Yeah.
So, but that's just basically the general flow of how each witness will work in our mock trial setting. And also in mock trial setting, we don't recall witnesses to the stand. Like in a real trial, you could do that. You could call somebody else. You could call someone back to offer more testimony in mock trial. they get their one shot and then they're done. Okay. And I can't see chat at this point, so
I'm helping with that.
awesome. Okay. So direct examination. The primary goal is to develop favorable facts. What do we need to prove? Okay. Or disprove if we're this defense. What pieces of the elements can this witness fill in? How do we get certain facts in? Which witness is better? Like if a witness has direct knowledge versus indirect knowledge, we might want to do it through one person. Um, we want to establish credentials for the witness. Why are they trustworthy? Why should we believe them? Why does their testimony matter? And also, we want to establish foundations for exhibits. Now, we'll get into exhibits a little bit more specifically, but some of the exhibits sometimes, keeping in mind again, I haven't read this case, sometimes we stipulate exhibits, meaning exhibit 2 is stipulated as authentic and da 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 da, whatever. That means you can just offer it into evidence. No witness has to do anything. Most of the time, you have to have a witness who can say what it is, why it's important, why it's legitimate. Okay. And we'll get to that in a second. But thinking about which witness is the best person to introduce exhibits. Sometimes that's one of your witnesses. Sometimes it's the defense witness, right? Sometimes it's the other side's witness. And it's important that in direct examination, most of the talking should be done by the witness. The witness is the
Yes.
star. Okay. The witness is the star. The question should be open-ended. Questions should be short and to the point, right? I'm giving you like an open-ended question and I'm going to let you talk. And because you want to let the witness tell their story in their own words. And we're going to go back to like, we learned this in like elementary school, like the basics of identifying a story or telling a story, the who, what, when, where, why, and how, right? Those questions are still relevant today and storytelling. And so these are how we're going to ask questions of our witnesses. Sometimes a yes or no question can be very helpful to kind of guidepost, right? When you got into your house, was somebody unexpected there? Yes. Okay, so tell me what you saw, right? Then you can kind of get into it. But for the most part, we're going to ask open-ended questions because we want the witness to be doing all the testifying and not us. And again, this is for the witness to tell their personal story that they have personal knowledge of. It is not, they cannot testify to somebody else's witness statement. They cannot speculate about things that they don't have knowledge of. Okay. I had a random note that had nothing to do with this. I typed it at the wrong place, clearly. Okay, so you want to make a plan. Generally, you're going to introduce them to the jury. You want to decide how are we going to do that? How are we going to make them appealable? Like what facts about them do we want to draw out? Like Mama Bear is like the Mama Bear in town, and everybody knows that her baby is the most important thing to her. And while she's like super open and giving, like she sets clear boundaries about people trying to take baby bear stuff, right? She's very protective, that sort of thing. And you want to set that out up front. What are the most important facts you need from each witness? Okay, so in this case, again, we're going to go back to our elements of the crime. We want to prove that it wasn't Goldilocks' property. We want to prove that she didn't have permission to be there, right? Our oh, I already said that part. Review the statement for anything that might discredit a witness, that might, and try to cover that up front and like in a more approachable, understandable way. Like Mama Bear, you've got signs that say like welcome home and come on in and super inviting stuff. Like, why do you do that? Just like I just want it to feel cozy for my invited guests, right? Not
Right.
for everybody in the town, not for strangers, but for when I invite people over, I want them to know that they're welcome. You want to explain changes in their witness statement. Okay, so in your initial statement, you said this, but then when you wrote your supplemental, you said you know your I don't even know what word we use these days, addendum, whatever. Your second statement, you said actually it was, in your initial statement, you said you were outside for like 5 minutes before you came back and found Goldilocks. And then in your follow-up, you said it was actually about 15 minutes. Like why is there such a discrepancy in your time? And then, you might use this witness to set somebody else up in a positive or negative way, right? If they have another witness, you can't say like, well, she's super trustworthy and da 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 da, but she can testify to things that will be consistent with somebody else's testimony if she knows it. And then that way, when that other person testifies with their direct personal knowledge, they seem more credible because, oh, like Mama Bear also said that thing. So it's
Mhm.
not just this one person saying it, right? Um, Okay, and so we have Goldilocks and the Three Bears. And so our witness for the prosecution is going to be Mama Bear. That's who we're going to be working with today. And the witness for the defense is going to be Goldilocks. Do you have any tips about direct exam you want to add before we get into like some examples, Stacey?
I feel like I had one, but I will pipe up. But I have forgotten.
Okay.
Oh,
Um,
one thing I was just gonna say is that when you guys go through the witness statements and stuff, just remember that these are written so that these cases and the materials are written so that there's going to be two sides to the case. So don't be like discouraged when you're like, every witness has something that could discredit them. Like that's just
true.
how these are written. So like like it's not the end of the
Yes.
world. Everyone's dealing with this kind of stuff.
Yes, we don't, we, and I say we, I've written in years past, but just not this year. But typically the goal is to make it so that it's very balanced because if there's nothing to cross-examine somebody about, it's kind of hard to have competition.
Right.
So we intentionally write stuff in to be able to cross-examine them in the first place. So with Mama Bear, we're going to start by establishing that she's warm, fuzzy, cuddly, lovely Mama Bear, first and foremost. Um, you can do that in a number of ways. Sometimes you can just say, introduce yourself. Sometimes asking witnesses to do that can go off the rails very quickly. So you give them a more guided introduction, like, can you tell the jury your name? Okay, and where do you live, Mama Bear? Okay, and how long have you lived there, right? Because if you ask Mama Bear to introduce herself, she's going to tell you her entire life story, right? So depending on the witness, knowing what they're going to say or do is very helpful. And so in terms of elements of the crime, we're going to we've already established that it's Mama Bear's house, that she lives there. She's lived there a long time. So going back to the date you first met Goldilocks, where were you that day? Right? Because she's gonna say Goldilocks is a stranger, by the way. She's never met her before. And she's like, well, I was outside watching Baby Bear because, little babies, they just love it when mommies like come and watch them swing, even though he swings every single day and it's the same exact thing. You still want, so I went outside to watch him swing. Okay, so how long were you outside? Oh, about 30 minutes, right? Like she might change her time. She maybe has changed the time or not. I was outside for a little bit, but not like super long. It wasn't like I left for 3 days, right? And what did you discovery? What did you discover when you returned home? A blonde girl sleeping in my bed, right? And so like I'm giving short answers here because I just don't have room on this too. But like, right, she's gonna get into the details, like, oh my God, like yeah, I opened the door and there's a girl sleeping in my bed who I've never seen before. Like, first of all, where did she come from? What's she doing? And like she's sleeping in my bed. Right? And giving her an opportunity to really tell, like, and how did you feel? And like, okay, so what did you do next? Like those sorts of questions. So, okay, was anything else missing? Was anything missing, misplaced, anything like that? Her porridge had been eaten. Their porridges had clearly, somebody had clearly taste tested them, messed with them, right? How do you know Goldilocks is the one who did that? She had porridge on her shirt. Couldn't have been anybody else. And she told me it was her, right? So there's some examples of questions you might want to ask her. They're open-ended. They give her a chance to answer as much or as little as she needs to in that moment. And these are things that you practice in advance with
Mhm.
your witnesses. Um, in trial, sometimes we're asking witnesses things for the very first time. Um, you're not doing that in mock trial. In mock trial,
Right.
you're asking questions that you have asked 100 times, that you've practiced over and over and over. So when you say, what did you see when you came back inside? Mama Bear knows to give you that full shocked answer of the details of like how it made her feel and da da da. And if she doesn't, then you can prompt her because like, oh, we've talked about this, and
Mhm.
some people have stage
Was
fright,
there
right?
anything in your room? Was there anything amiss in your house?
Yes. So those are some general questions that you can kind of ask as an example of Mama Bear.
Yeah. And
Okay.
if anything, it's like sometimes witnesses, like they have a lot to get out or a lot that they want to say, or they're just like a witness who they're kind of like talking a lot. And if they kind of gloss over an important point, you can always kind of like go back to ask something more specifically, like, you saw this blonde girl. Did you notice anything about her shirt? Like, did you notice anything that was weird? Well, her shirt was covered in, or was like, so you can always like kind of redirect to like emphasize something, but you don't want to lead them there. So if they kind of like go through a lot of text, you can bring them back. But you don't want to ask the leading questions like, when you went inside, did you see a girl?
Right.
That doesn't work. You have to let the witness explain what they
Yeah.
saw.
You found Goldilocks just lying in your bed, didn't you? Like, no, that's not allowed on direct. We'll talk about that on cross in a second. Um, the other thing is if your witness is kind of going off the rails a little bit, and or if the other side objects to like narrative or something like that, usually we don't have that a lot in mock trial. But like, let's say they cut it off, but you're allowed to keep asking questions about that. You can just say, okay, then what happened next? Or, okay, how did you feel about that? Like,
Mhm.
kind of guideposting them to like the next part of their answer that they didn't quite get to. Um, and again, we're gonna go back to elements of the crime. So with Mama Bear, especially, you want to prove that like it's her house. She did not invite Goldilocks in. There was
Mhm.
no reason for Goldilocks to think she was invited in,
Right.
right?
She's got a little baby. She doesn't just let people come in her house. Like
Yeah,
there's a lot of different ways that you can allow
yeah,
her to explain her reasoning there.
right. Okay. And so for a direct exam of Goldilocks, you're going to go the other way. You're going to show that she thought it was reasonable, that she was invited in, that it wasn't trespassing, right? So, well, tell me what you saw at the house. Well, I saw a sign that said, come on in, and the door was standing wide open, right?
Welcome, friends.
Yeah. Um, and what did you see when in? Well, a pillow that said, welcome home, right? Like,
Porridge over here.
what did you do once you were inside? I made myself at home as I was invited to do. Okay, and how many people were inside the house? Nobody. I had no reason to believe that other people were there, that I was interfering with anybody else's ability to be there. Okay. Um, Admittedly, in this particular case, it's a little bit harder to defend Goldilocks, like unless we've got really, so like in this case, we've written in some evidence that Mama Bear actually does invite people in a lot, right?
Mhm.
And so we'll get into some cross-exam questions in a second to like poke holes in their stories. But that's, as Goldilocks, you want to make her look sympathetic and reasonable, but also that like her story makes sense. Like she wasn't going into somebody's house uninvited. She thought she was invited. She was allowed to be there.
Right. And this was noon. This wasn't like 3 a.m., right? Like this is a normal time when you would visit someone's house
Hmm.
or you would eat.
Oh, how long were you there for alone? Forever, because she fell asleep. So she she thinks it was like forever.
So long.
That's a little kid thing also. Like kids are like, "Oh, it's been forever," and you're like, "It's been 3 minutes." Um,
Humans, am I right?
okay, so that's kind of generally how direct works. We're trying to get them to tell the story in their words, not in my words. Like, so what did you see? Who did you see? How long were you there? Tell me all the details about the house. Why did you think you were supposed to be there? Like, she's already gonna say, I thought I was supposed to be there. Okay, but why did you think you were supposed to be there? Gosh, she's got like 17 signs that say this is your home. Home is where the heart is. Like,
Yeah.
home
Who
is where
but
you eat your porridge. Like all these different things that like it just like it was telling me that this is my home.
so just remember like the who, what, where, when, why, how. Like from the beginning, like try and make your sentence like your questions freight, like try and make them that way. And then you can later go into like more like make it sound more like you. So like tell me what you found at the house, but like what you're really starting is like, what did you see at the house, you know?
Yes.
But then like you can make it sound more normal later, but you want to
Yeah.
make sure your questions are phrased in an open way.
And then when you're doing your scripts, I'll tell you, I always try to do scripts for my trials, particularly my direct exams. I don't always know. I do family law, so I don't always know who's going to appear to cross exam. So it's hard to plan those in advance, but my directs I can usually plan pretty strongly. I don't always put the exact answer. I was going to say this when we were talking about guide posting. I don't put the full answer that I want the person to say. I have like outline, right? What did you see at the house? And then it would be sign, open door, da 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 da. So
Things
like
you
if she just
need.
tells me about the sign, I would say, okay, what about, can you tell me about the door? And then that
Mhm.
would trigger Stacy to go, oh, right, the door was standing wide open. It wasn't closed, it wasn't locked. I was able just to walk right in the house without touching it. And so that way it's guideposts to me, but it doesn't lock Stacy into feeling like she has to say
Right.
exact words on her side of it. So that can be really helpful if you're the attorney, is to kind of guidepost yourself with the answers as you go through your script. Okay, so cross-examination, what time is it? 11:25. Okay. Cross-examination, we're going to try to undermine unfavorable facts or bolster favorable ones. We want to discredit the witness and their testimony, which includes showing bias, such as if somebody's being paid, if somebody, if one of the witnesses for Mama Bear has a history of hating little blonde girls, for instance. We want to kind of pull that out of them. We want to show limitations, weaknesses, or inconsistencies. Um, okay, like you saw Goldilocks buy the house, but you didn't see her go in the house. So you can't actually say she was there or how long she may have been there if she was, right? And you want to be prepared to impeach witnesses for the most important facts. And I say this because please don't spend your time impeaching somebody over a very unimportant fact, right? If they can't remember, I'm trying to think of an example here with Goldilocks. Um,
If the pillow said like welcome or welcome home,
right,
or
right. If it said, yeah, if there was three pillows
they
that said
both
that or
said
two,
welcome, yeah.
yeah, right. Like let's not impeach over like minor quibbles, but if Mama Bear's like, I don't have a single pillow that says welcome home, I don't know what you're talking about, then you would want to impeach her on like her fact statement, and we'll get into that in a second on how you can do that. But that would be something relevant, right? If she says there's no pillows that say that, that's when you want to impeach her because now that's not consistent with what she said in her written statement. On cross-examination, you are in control, not the witness. The attorney is the star of the cross-examination. Um, can you guys still hear me? Because Stacy is frozen on my screen. Okay, great. I when that happens, I'm not sure if I'm the one frozen or if it's somebody else. Okay, so we want to make a plan. We want to organize, so that's super important on cross-examination. Um, we need to know what questions we want to ask, what facts we want to ask. In this case, like I was saying, I don't always know who I'm going to cross in my cases in real life, but in mock trial, you do. You have their witness statements. You can go through and figure out exactly what points do you want to talk about. What undermines their story? You don't want to jump back and forth between topics. You want to try to do it in a much more logical flow to show that, okay, she said this here, but then she said this here, right? You want to kind of make it flow a little bit better. Um, Questions should be one fact at a time, not multiple facts. If you ask somebody like a compound question, it's not technically against the rules, but you're not going to necessarily get the answer you want, right? If I ask Stacy, isn't it true that you're a lawyer and you live in Michigan and you're super mean? And she says, no, like, what did she just say no to, right? It's not a clear answer because I didn't give a very clear question. Stacey, it will not let me make you a co-host out in here.
Okay.
I don't know what that is about. It might be because I'm sharing right now. Um, okay, and then on cross-examination, know when to stop, right? You don't need to cross-examine somebody about every single detail of their witness statement. that gets kind of boring. You want to cross-examine them about the things that matter to your case. Okay. Um, and you want to avoid giving the witness time to talk or explain, and we'll talk about ways to control the witness as well. But we want to primarily be asking closed questions that can be answered with a yes or no, preferably with a leading question, because that way we can kind of really guide the witness to say what we want them to say. Okay, so the goal of cross for the prosecution is to show that the defense. Okay, first of all, on cross-examination, we want to see if we can get anybody to admit to an element of the crime or to agree to an element of the crime, right? Goldilocks, this is not your house, correct? Correct. We also want to show that the witnesses are untrustworthy or incredible. You shouldn't believe them. Helping them prove your case, right? Proving up those elements of the crime. The goal of the defense is going to be to show that the prosecution witnesses are untrustworthy. They don't know what they're talking about. There's holes in their story, or to disprove elements of the crime. Like, Mama Bear, isn't it true that you invite literally everybody in Fairy Tale Land over to your house at least once a month? Like, are you okay, Stacey?
I'm stuck. I'll figure it out. Sorry.
Okay. Do you have any other tips for cross-exam?
I think for Cross, the most important thing is that you are the star at this point. So, like, you are controlling the witness, I think cross exam is when you can be so prepared, um, phrase your questions very, very carefully, so that you know exactly what they have to say, yes or no, right? And then I think the other piece of advice is know when to sit down. So on cross exam, like your job is to like poke certain holes, especially when it goes to the elements of the case. And so know when those holes have been poked and you're done. Because, if you keep just quibbling and going on forever, the real important points that you got out there, they get lost. So while you want to show your advocacy, it is also important to know like when that advocacy is done because you've done your job.
Exactly. And so I think it's also important to know, one of the things I see beginners make mistakes about a lot in cross-examination is asking open-ended questions that they don't realize are open-ended. And so then you know, um, I think I asked a yes or no question and the witness isn't answering that way, so I'm going to object to non-responsive. They're not responding to me, judge. And like me as a presiding judge, I'm like, actually, they are responding to the question that you asked because it wasn't as clear as you thought it was. And so this is, like Stacey said, an area where you can be super prepared and make sure your questions are really dialed in. So what information you want to get out. Um, so some examples of cross-exam of Mama Bear. So, right, remember the goal of the defense is where we want to discredit Mama Bear. We want to disprove elements of the crime. Okay. So, isn't it true that you have a sign outside that says "Come on in"? And you have a pillow that says "Welcome home"? And you invite people in for porridge all of the time, right? And you let her wake up on her own instead of making her get out of your bed and leave, right? You left her there for some period of time. So like why would she believe that she wasn't supposed to be there, right? Um, these were very late night examples that I came up with last night, just so we're clear. Um, with more time, we could come up with even better questions to cross-examine Mama Bear. Like, yeah, you lived there a long time, but you let people stay with you all of the time. Like you're known in Fairy Tale Land of being the place that people can go when they need a bed to
Right.
sleep in, right? Like, that's a reputation that you really like having for yourself, in fact. Um, things of that nature. And then, in this case, if we're gonna cross-examine Goldilocks, we want to show she's guilty, right? In this case, because she's the defendant. What facts can we pull out of her without getting her to like again, where she's not going to be allowed to say in mock trial, I trespassed, right? She's not going to be saying I'm guilty of trespassing. But what else can we do to show she's guilty? Okay. The porridge was steaming hot. Like, you didn't make the porridge. Someone else made the porridge. So someone else clearly intended to eat that porridge. Like, it wasn't for you,
No one
right?
makes porridge just for fun. They make it to eat it, right?
Right.
Or you didn't build this house, did you? And you didn't like the door was closed. You had to open it to walk in, right?
mhm.
So all those things that show that like it's not hers. It's all
Right.
those things that you know that she has to admit.
Like, you know, the house belongs to Mama Bear. You've been told that it belongs to her, right? Yeah. And did Mama Bear didn't invite you in, right? You know. Um so just things that you can kind of pull out of her that will show that, like, she definitely knew she wasn't supposed to be there. She knew she wasn't invited. She knew she couldn't stay, right? Details of that level. Okay. And then in terms of we talked a little bit about impeachment. Um Impeachment can be very complicated, but I'm going to say the number one thing that people do wrong on impeachment is the first thing you have to do is to give them a chance to explain their inconsistent answer. Okay. So if in Stacy's witness statement, she says, I saw Goldilocks go in the house and I never saw her leave. Okay. And then she testifies and says, I saw Goldilocks go in the house and later I saw her leave. So those are not the same thing. That's a
Right.
different thing, right? I can't just whip out her witness statement and say, "You're a liar, Stacy. Look at your witness statement right here where you said something else." I first have to ask her, "Have you ever testified differently?" Right? And then if Stacy says, "Well, yes, I have," then I have to give her a chance to explain, right? So if the difference is that actually she cleaned it up in her second statement, right? I have to say, "Oh, why did you testify differently?" And then Stacy, you would say something like,
I forgot.
"Yeah,
I
um,
lied. No,
right."
that's not what I would say.
Not I lied, but one of the things that happened in a trial last year was one of the witnesses misspoke. He was a very good witness. He just said the wrong thing, and they impeached him correctly. They asked, "Have you ever said anything differently?" And that was his clue because he knew his facts really well. He went, "Oh, I'm sorry. I misspoke. I meant to say da 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 da." That was done. The impeachment was over. There is no impeachment in that case because he's been given an opportunity to respond. He's been given an opportunity to clean it up. Now, if Stacey says something different and I'm like, "Hey, have you ever testified differently?" And she's like, "No, I've always said the same thing." Be like, "Okay, well, do you recall writing a witness statement?" Okay. And like I said, a good witness will immediately correct their answer because they're going to realize, like, "Oh, I said something wrong." Or they'll kind of go along with you, like, "I think I misspoke, but I don't really remember what exactly I said." Um, but do you recall doing a witness statement? And then if you get to this part, another thing that I see that kind of goes sideways very quickly, I hand Stacy the witness statement. I'm like, "Can you read from line 17?" And then Stacy's like, "I don't know which line is 17. Which part are you reading?" I'm very confused. Like, there's genuine confusion, and I'm not saying that it's like in real life it's put on people being difficult. In mock trials, generally it just kind of devolves into a little bit of confusion. So instead, it's like, "Okay, I'm showing your witness statement. This is your witness statement, and you signed it." And she'll be like, "Yes, that is my witness statement." "Okay, I'm showing you page 3, line 14. I'm going to read it out loud. You read along with me and let me know if I say something wrong." Okay. I saw Goldilocks go into the house and I never saw her leave. Did I read that correctly, Stacy?
Oh, you did.
Okay. And that's what you put in your witness statement.
I I I said it's in there. Yeah.
Okay. So would you like to correct your statement here today in court that you said you saw Goldilocks leave?
I well, I mean, and then they fumble and you win.
Right. So that's how you like impeach somebody correctly, right? But you have to start with, have you ever testified differently? And if they say yes, can you explain it? Okay.
The
Um,
other piece that sometimes I think in a good example of like what comes up often in like a criminal trial is when they didn't say something in their original statement And so you're trying what they did later. And so one like line of questionings, you'd say, okay, like Officer Bear, like you're a police officer, right? And so it's important that you write all the details. And you do that. You've done that for 15 years, right? So you make thorough statements and you put them in there so the prosecutor has all the information, right? Yes. And you think you do a good job? You try your best? I do. Okay. Now, if you saw Goldilocks leave, you would say so, wouldn't you? Right? That would be important to write down. It would, And you wrote it down 5 months later, didn't you? In your supplemental statement. But can you show me in your original report, did you write that down? You didn't. Oh, you didn't. Okay. And so like that's another way to impeach kind of is by saying like something isn't there.
Yeah.
And so that's kind of a way that you get around.
Yeah.
I guess maybe it's not impeaching, but it's kind of like saying they didn't.
It's like impeaching by
By
absence
omission.
by omission. But I'd also be careful with that in mock trial because I've seen that also go off the rails because then the
Right,
witness is trying to like read their statement
Yeah,
line by
yeah.
line.
They're like, I don't know.
Okay, but no, you put it in your addendum because you didn't put it in your initial
Right.
statement, right? Because you forgot the first time. Okay.
Yeah.
All right, so that's generally how we're going to examine witnesses. We're going to ask them questions. We're going to let them answer. On the one thing I left a slide out for is controlling your witness on cross. So if I am asking Stacy a really good, clean leading question,
The answer will be yes or no.
yes.
It's a closed question.
So
There is not an option to explain.
you have a pillow that says "Welcome home," and Stacy's like, "Yeah, but I have 1,700 pillows," and da, 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 da. And she's picking out the, like that's what she wants to say.
Yeah. She goes, ma'am, yes or no?
Yeah, in reality, it's yes or no. But if she answers yes, if she says yes, but objection, non-responsive after yes, that's it. Because she answered the question. I don't need any other answers. I don't need any other explanations. So sometimes what I see with beginners where they get confused on their cross examinations is they very accidentally slip in that like open-ended question of like, okay, but you have a pillow that says yes, but you're saying you don't have a pillow. So which one is correct? And then she's like, well, I have a bunch of pillows. I don't have, because now you've actually opened the door for her to really give a long, rambly answer. It wasn't as clean as you thought it was
So
on
you
that
can, and then
clarification.
in that situation, like you can always say like, you know what, you have given a lot of information. I'm going to strike that question. I'm going to try it again. There's a lot of ways that you can like recover to like, if you really need to get that point in but that's where you need to go back and you need to really rephrase the question to make sure. And sometimes you go like true or false. A
Mhm.
pillow says welcome in your home.
Mhm. And just because, like, we're going to talk about this again in a minute, Stacey's already talked about it, just because a judge sustains an objection or overrules an objection in this case, like, if I object non-responsive and the judge is like, actually, I think it was super responsive to the question you actually asked, I'm like, okay, I need to go back and ask a cleaner question then so that I get the clear answer that I want to this
Yeah.
information.
And you just go, okay, let's try this again.
Yeah.
So, like don't worry that it means you're wrong. Sometimes it just means like try a different way. The judge will let you
Exactly.
know if you need to move on.
Exactly. Okay, so introducing exhibits for beginners. I said this kind of we were talking about the rules general or earlier in Stacy's when there were questions asked about exhibits, but if an exhibit is stipulated, you don't really have to lay a foundation. We had one a couple of years ago that was like a map or something, and it was stipulated as long as a witness could identify it. So all a witness had to say was like, yeah, that's a map of the town we live in, and then it could be admitted in. It didn't need a full foundation, didn't need a full explanation.
So
Again,
so just like to as a high level foundation, like if you think about like the proof that we have in trial, we need to make sure that it is what it says it is. Like I can't just
yeah,
like draw something and be like, oh, isn't this a map of the town? So we need to
right.
make sure that someone who knows the town can say, I know the town, I'm familiar with it, I've lived there forever, and
Mhm.
that map looks like it. So we need to make sure that our evidence has foundation to establish that it's truthfulness, basically, or like its reliability. So that's
Okay.
what these are for.
Okay. And so to be very clear, because there was some confusion last year in a competition, witness statements are not exhibits. They
Yes,
cannot be offered as exhibits. You can
correct.
use them as an impeachment purpose, and you can read parts of them to a witness as part of an impeachment. You otherwise cannot read them into the record. You cannot admit them into the record.
Right. They're just there to help you know what the witnesses are going to say in your direct and in your cross.
Yes. Okay. So a very basic way of thinking about exhibit foundation is like, what is the thing that I'm showing you generally? How do you know what it is? Is it a fair and accurate depiction, right? If it's a picture, or is it a true and correct copy of a document, right? Is it really the thing?
Mhm.
And has it been changed in any way that you're aware of? Okay. And then you, assuming you get the correct answers to all those questions, you're going to offer the exhibit into evidence. The other side will have an opportunity to make objections or not, and we'll talk about that in a second as well. And then only if it's admitted into evidence can you ask for permission to publish to the jury. You cannot publish an exhibit that has not been admitted into evidence.
The jury can't see it.
Okay. And in our cases, in real life, we have like PowerPoints, TV things. We have all sorts of
Yeah.
ways of publishing. For our trials, we're like old fashioned, going back old school. You get to bring the piece of paper to the jury, is what you get to do. We give them back at the end of the trial. We don't
Yes.
keep them. You don't need hundreds of exhibits. So, but that's just part of it to show that you know the steps, that you know, okay, now I get to actually physically publish it to the jury.
Mhm.
Okay. Um, in terms of objections, you want to review each and every exhibit to see what objections, if any, can be made. Every single one of them. Whether it's good for your case or bad for your case. Figure
Yeah.
out if an objection can be made. And then after you figured out all the objections, what's the response to try to keep it in? Okay.
Mhm.
Oh, I think they can make a hearsay objection to this one. Okay, but it would be an exception because it's actually a business record, right? So then you can go back and you can prove it up slightly differently. Okay, so I've determined that this exhibit I want to get in is actually a business record. So instead of just saying, oh, this is, the record of whatever happened and it's a true and correct copy, now I'm going to also put in the questions regarding a business record. I'm going to say, okay, Stacy, was this a record made at or near the time of the events in question?
Yes.
Yes. Was it made by somebody with actual knowledge of the events?
Yes, that was me.
Okay. And are these records that are kept in the normal course of your business?
Yes, this is the kind of document we keep all the time.
Okay. So then I'm going to offer it into evidence at that point. If I don't do that, if I just go, oh, this is your record of what happened, and it's a true and correct copy, and then I try to offer it into evidence, the other side could go, objection, hearsay. Right? And if I say, well, it's a business record, it's like, well, you haven't proven that up. Maybe you want to ask more questions, right? So sometimes at that point, as a presiding judge, I'll say, sustained, but you can ask more questions, right? And then if you still can't figure out the questions, I might still keep it out. But if you come back and then you ask those business records questions, okay, now you've cleaned it up. So, um, and then even if you don't care if an objection comes in or not, always have those responses ready to give to the judge because it shows us that you've really thought through it. You've really
Mhm.
thought through that exhibit, why it matters, how it can come in, why it's a legitimate piece of evidence, or why it shouldn't come in, right? That's really helpful for us because that's a skill that is showing that you've mastered. Even if you're not like super advanced, this is something even beginner students can do, is just find a reason to object to every single piece of evidence. I have done that in a trial. I did it at what's called a temporary orders hearing, where we don't always know the evidence in advance that the other side has. And she had a whole stack of exhibits, and I objected to every single one of them. I found a reason to object to every single one of them. And by the fourth exhibit, after the fourth one, she stopped trying. I don't even know what the rest of her exhibits were
It
because
may
she
have been
stopped.
good.
They may have been good exhibits for her side, but she had no idea what to do after the fourth one. They were all legitimate objections, to be clear, but it's like she just completely stopped. And so, don't be that person also. Don't just give up. Don't just let it die. Keep trying.
So the one thing I think that would,
Oh,
to put this in context, so when you go, you say like, I have what has been marked as Goldilocks Exhibit 1. I'm showing it to the witness. So you're gonna give a copy to like opposing counsel will now that they know that's Goldilocks Exhibit 1, they can flip to it, And so they should be able to like look at it in real time as well. So when she was talking about the example with opposing counsel and all these documents, she was able to look at a copy so that she can say, oh gosh, that doesn't look like there's no signature. This doesn't look legitimate at all or something, so that's kind of how you'll be able to look at what they're talking about and know your objections.
Um, Right. And so the way we do that in mock trial typically is because, like Stacey said, everybody has all of the exhibits already. You don't need extra copies to give one. Like, I'm not going to have extra copies so I can just hand one to Stacey every time. I'm going to show her, I'm going to say, this is exhibit 3. And then that way she can look at it. She can look and make sure it's
Yeah.
exhibit 3 that she has. And then we're good to go. That way we know we're looking at the same thing.
Yeah. And like no one's gonna pull a fast one on you, but like, yes, check, okay, 3.
Just in case.
I've never seen that happen in mock trial. That would be crazy, but that's not gonna
I've never seen it happen either. So like some possible exhibits that we might have, like Baby Bear loves to take photos, so he snapped a photo of Goldilocks sleeping in the bed. We don't have to have Baby Bear to put that in, right? Mama Bear can put that exhibit in because she saw Goldilocks sleeping in the bed, right? That's Goldilocks sleeping in the bed. I was there. That's a fair and accurate depiction of the events that happened. There's nothing else added. Nobody like photoshopped in like little ducks or whatever. Like there's
Right.
no extraneous things that have been added to this. Nothing's been taken away from this. This is a picture of what actually happened that day. And then, okay, I'm going to offer exhibit 1 into evidence. Admitted. Okay, now I'd love to publish this to the jury. Okay, so that's just like, again, trying to give you guys a beginner level of exhibits that everybody can master without worrying overly much. I would say if you're a true beginner and you've never done it before, don't try to do 17 exhibits.
Right.
I think there's 16 in the case. So
Focus on the most important ones that you have to win.
Yes. If an exhibit has already been put into evidence, you don't really get credit for proving it up a second time.
Yeah.
So if you each want to show that you have that knowledge, you're going to have to find 3 different pieces of evidence that you want to get in to do one at a time. And that's fine. You can if you manage to get through the whole trial without putting a single one in, I would probably hold that against you for not trying. But if you only manage 3, that's fine too. You don't have to do all 16. And generally, there's no preference or priority as far as the scoring judges go. I don't care which ones you put in or don't put in. I want to know that you know how to do it correctly. Okay, and so objections for beginners. We're going to try to speed through this because it's 11:52, so we don't have a whole lot of time. But this is the last bit that I have. Make a plan, have a cheat sheet. You can have your most common objections right there in front of you. So while you're listening to testimony, you can be like, ooh, objection hearsay, right? Don't object to every single question just because you can. I'm not going to give you extra credit because you objected to 100 questions.
No.
That actually is sometimes kind of annoying because you're objecting to things that shouldn't really be objected to. Object
So
to the
just
important
remember
things.
that like objections, like for like if you're the jury, like it can get annoying and that takes away from your advocacy. But when it's a good objection or like makes a point like that will help to discredit their case and it needs to be done, that's when you make an objection. So like try and use your good judgment there. You do not win a case by objecting forever. That doesn't happen.
Sometimes people like to object to every single leading question they hear somebody do on direct examination. I sometimes lead on direct examination for foundational questions like, okay, and you live at 123 Fairy Tale Lane, isn't that correct? Like that's a leading question. It has nothing to do really with like the facts of the case necessarily. Like no one disputes that she lives there. If you start objecting to leading to those kind of questions, you're mostly just getting in the way of yourself.
And the objections are in their packet, right? The rules have
they have a rules of evidence.
Yes.
And so the objections are based on the rules of evidence. So like in the competition rules, there are a list of objections. That's not an exhaustive list. You can make other objections within the rules of evidence. So don't give up because the other side is objecting a lot. like I said, it's not necessarily helping their case. I've seen that. It breaks my heart when
Yeah.
Stacy's asking her questions, she's doing her best. The other side objects, and Stacy just finally gives up and sits down. I'm just
Yeah.
like, ooh, bless your heart. I feel bad for you, but now you've kind of lost it on the advocacy because you gave up.
And just remember that we talked about like a rule of thumb. If like you're kind of lost, you don't have, you don't know all of these rules of evidence and like you just don't. That's a lot to get to know, right? So if you don't know all of them, listen to their objection. If they say, objection, this is hearsay, you can respond and at least try and say, this is not hearsay. At least go there, right? Like just do your best to follow the language because at least then you've responded. It might not be the best response, but at least the judge is aware that and they're judging you and they say, well, they're listening. They said it wasn't hearsay. They didn't really explain why, but they got there, right? As opposed to just being like, I don't know. You can always at least say some of that language back. Or they say, objection, Rule 403 prohibits this. And you'd be like, Rule 403 does not prohibit this.
Even
Do
if you
that.
have
That
no
gives you,
idea
right?
right.
That gives you something. Okay.
Yeah. Okay, so and like we said earlier, objection doesn't mean you can't get it in. Take a brief pause, take a second in your brain, see if you can ask a question differently and do it differently. Basic format, we want to stand very calmly. We don't want to yell at anybody. We don't want to scream and shout. We're not arguing with opposing counsel. I'm not saying
Do it.
objection and like looking at her very hatefully, even if I want to do that inside. Objection, Your Honor, leading question. If I need to give an explanation, I will, right? If the judge asks me for further explanation. I typically, as presiding judge, don't really care if you explain it initially, as long as you give me a valid, I don't need a definition if you can give me a valid objection, right? Objection, hearsay. Okay, do you have a response? Okay, well, it's an exception to hearsay because blah, blah, blah. Actually, it's not an exception to hearsay because, right? And I'll give you a chance to come back and kind of rebut it. Don't yell, don't shout. We like to ask for objections. I'm not going to ask you guys or responses rather. I'm not going to ask people to go back and forth a whole lot because then we just run out of time, even though time is paused for objections, but it gets a little tedious at that point. Once I feel like I've gotten the full argument from both of you, then I'm just going to rule and we're going to move on, is usually how most of us judges handle it. Objection, speculation. The witness has no direct knowledge of what's being asked. Well, do you have a response, Ms. Nolte? Well, actually, the witness saw what was happening, so it's not speculation. She's just testifying to her personal knowledge.
She just testified she was in the room, and I've just asked her about what she heard and saw. So,
yep. If you don't have a response, say something like Stacy said. Just flip it. It's not speculative.
right. It is not speculative. You're like, I don't know what speculative means. You know what? Just say it's not, Your Honor. And then you can always say too, and this is like not substantively the best suggestion, but if you can't flip the language, it's not speculative or whatever, you can always say, and it goes directly to the element of X. So you just kind of emphasize why it's important. So sometimes just saying that at least like helps us as a judge know like why this piece of evidence is relevant and important. So you can always say that too as a point of like, it's not blah, blah, blah. This evidence goes directly to whether or not Goldilocks knew she could come inside.
Okay. Witnesses, if there's an objection, you stop talking. You don't do anything else. You are a fly on the wall.
Yeah.
I have started saying this because I had an issue a couple years ago with a witness who liked to talk during the entire objection. And when I say talk, I don't mean she continued testifying. I mean, she started talking about how she was, in fact, being very responsive to the questions that were being asked of her. She didn't understand why he was objecting to her. And I finally had to say, I don't need your help making a ruling here. I need you to stop talking. And so if you're a witness and the judge has to tell you to stop talking, you're already on the wrong side. I will just say that. Okay, I had a couple of examples, but we don't really have time for that. So I will just say practice, 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 practice. When you guys are in practice, object to each other all of the time. Get your friends used to being objected to. Get your friends used to having to like explain why it's not a hearsay, why it's not like leading, blah, 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 those kind of things. The one thing that I did highlight, leading questions are questions that suggest the answer. It's not necessarily a yes or no question. Okay, so I see that a lot. I asked Stacy, was the light green? The difference between leading and not leading, the light was green, correct? Like that's a leading question. I'm telling
Like,
her I want her to say
yeah,
yes.
yeah, it was green.
Yeah. Was the light green? She could say yes, she could say no. I haven't told her which way to go with the answer at all. A yes or no question is allowed on direct. A leading question is not.
Right.
Okay.
So like, and when you open the door, did you see Goldilocks with porridge on her shirt? Like that is you testifying and not the witness. So that's why it's not allowed.
Yes. Versus, did you see anything on her shirt?
Mhm.
Right? And I could say, no, it was clean. It's fine. I don't know. Okay, hearsay is super complicated. There's lots of resources on the internet that can
Yes.
help you with hearsay. We highly recommend doing that.
Yeah.
But really just practice. That's all we can recommend for objections is like the more you do it, the easier it gets. The more it helps your witnesses figure out when to stop talking, but also like just the more you're getting objected to, the less stressful it
Yes.
is.
Yep. And
Because I
that's
would
the
say
most
as a
important part
yeah,
is just chilling out.
as a baby attorney, the first time you get objected to, you just like, what do I do? And so it helps like later, the more you've been objected to, the more you're just like, meh, whatever.
Yeah. It
So
is not speculative.
no. Okay. Stop share.
So you guys are going to do great. The one thing I want to say that I think is really important to know is that there are so many different kinds of advocacy that are effective. Some of the best lawyers, trial lawyers I've ever seen are the people that you would be like, I would never think that person would be a trial lawyer, let alone like they kind of are quiet and they do this. So just know that like it doesn't have to look one way. Do what works for you and what feels comfortable. Follow, of course, like what we've laid out here of like how you need to ask questions, but just know that like you don't have to pretend you're like a lawyer in a TV show. Ask the questions the way that you want to be the advocate you want to be and what feels natural, because the more you're thinking about this and practicing on your own, just be your authentic self, and it will come across great.
And then one tip for opening closing statements, because we didn't really have time to get to that, but um, most people write out their opening and closing statements. That's totally fine. We do that as attorneys. Read it out loud to somebody before you nail it in. Because how the way I write is very different from the way I talk. And
Mhm.
so if I write something beautifully and I start reading it, it sounds incredibly awkward and I will start stumbling on those words because that's not
Yeah.
how I speak. So you need to make sure your opening and closing statements fit how your voice, how you actually speak and can present
Mhm.
information. That's the number one tip I give people because
Mhm.
if you start stuttering over your words, it just goes downhill very quickly.
Yeah, yeah, because it's more about getting the message across than how exactly the message is said. You just want to get your point across, and whatever way you can do that effectively. Like I don't use big words. I talk like in very clear, small words because that is what works for me. And if I start thinking of like long words that I need to say to make it sound really nice, I will lose my train of thought. So
Okay. I don't want to make you guys stay any longer if you don't want to, but if you have questions, I will still be here for a few minutes. I don't know if Stacy needs to run or not, but we're still here to answer some questions. If anybody wants some more information, we thank you guys so much for coming,
yeah,
and we're so glad we were able to do this for you guys again. And we wish you all the very best of luck
yeah,
in your competitions.
have fun.